Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Alicia Downey, and the title of today's episode is What's Going On with State Antitrust Enforcement? An update from the front lines. In recent years, efforts by state attorneys general to enforce the antitrust laws have been in the news far more than in the past. State AGs have taken the lead in challenging no-poach agreements and pursuing cutting-edge theories in the prosecutions of big tech companies. Today, we'll be talking with Milton Marquis, an antitrust practitioner in private practice with decades of experience representing clients in state investigations and enforcement proceedings. We'll hear from him about the current enforcement scene and where he sees the state AGs trending in the future. My co-host today is Melissa Maxman. Hello, Melissa.
Hi, Alicia.
Would you like to introduce our guest?
I'd love to. So Milton Marquis is a member, at Cozen O'Connor. He has for decades represented large companies in connection with matters involving or having the potential to involve state attorneys general and other enforcement agencies. And he counsels companies on how to mitigate the damage if they are a target of an investigation by a state authority, and he guides clients towards achieving their best possible outcomes while minimizing interruption to their business. Welcome, Milton.
Well, it's great to be here. Thank you, Alicia and Melissa. And what you didn't say, Melissa, is that you and I were law partners at one time.
That is true. I left that out, and I shouldn't have. Milton, among other things, is my former partner and my dear friend, and I am delighted that he decided to join us today. I know you're a very busy guy, so thank you. Well, let's jump right in. Why don't we give us some more background about yourself and how you started in the antitrust sphere, and in particular in the state AG sphere?
Well, I grew up in Southwest Georgia. And attended undergrad at the University of Georgia, or as we like to say, the current national champion football, University of Georgia, and went to law school at Case Western Reserve Law School in Cleveland. And then from law school, I wasn't sure what I wanted to do. So I was a legal research and writing instructor in Boston, Alicia, your hometown, your current town, at Suffolk Law School. And while teaching at Suffolk Law School, I became aware that the state attorney general's office was hiring lawyers. And I had an interview with Barbara Anthony, who was the then chief of the Antitrust Division in the Massachusetts Attorney General's office. And I had taken antitrust and economics in law school, was a summer law clerk at the Federal Trade Commission and the Consumer Protection Bureau during my second year of law school. And so Barbara hired me, and as they say, the rest is history.
Well,
so I got started in antitrust, and Barbara Anthony was a former antitrust division DOJ lawyer. Then, of course, she's gone on to be a deputy attorney general in Massachusetts, a cabinet official in Massachusetts, and the New York regional office chief at the Federal Trade Commission. So Barbara was my first antitrust boss, mentor, and very good friend.
So let's go back to that first job. So you were in the state AG's office in Massachusetts. What were your duties interfacing with the U.S. Department of Justice Antitrust Division?
Well, I was a starting lawyer in Massachusetts. Was an assistant AG during the typical things that state lawyers do, investigations, litigations, that sort of thing. I didn't have that much interaction with the DOJ at that time, but I did have a lot of interaction with other state AG offices. At that time, there was a group of antitrust officers in the East called the Eastern States Antitrust Council or Committee. I can't remember what the C stood for. And the meetings were always in Boston. And so you had states as far south as Virginia, New York, Connecticut, and Maine. So I guess maybe Boston was central, at least as far as the upper New England states. And so I worked a lot of multi-states. And while in Boston, I met a fellow, Frank Seals, who was my second antitrust boss. He was the chief of the antitrust unit in Virginia. And so Frank and Barbara were former DOJ colleagues, and being a Southerner, Frank gave me an opportunity to depart Boston, great city, but it was far from home and very cold. So I made it. I'd always intended to practice in Atlanta. I took the bar. I've been a member of the Georgia bar for 35 years or so. Never practiced in Georgia, so it's free bar dues for the great state of Georgia, and so that's how I ended up in Richmond. And from Richmond, there I was recruited to work at the DOJ under Ann Bingaman and then Joel Klein. So that's how I ended up at the DOJ. But worked a lot with other states, but not so much initially in my career with the DOJ.
Got it. And traditionally, in my memory anyway, the states AGs work closely together, but not as often with the federal authorities as they are now in, for example, some of the high tech, big tech litigation. Can you trace for our listeners how that change has happened over the years?
Yes. So when I graduated from law school in 1984, during the Reagan administration, the Reagan administration had views on antitrust that differed from Carter, that differed from Ford, and differed from the antitrust enforcement philosophy of most state attorneys general, and that's bipartisan, Republican and Democrats. So there wasn't that much interaction between the feds and the states at that time. Now that changed when Bill Clinton was elected president, and Ann Bingaman who was the first assistant attorney general in charge of antitrust. So she made collaborating with state AGs a top priority. Chairman Steiger and then Chairman Pitofsky likewise made working with state attorneys general a high priority. So instead of what had been a fairly antagonistic relationship between states and the federal antitrust authorities, became more of a partnership. And so Anne created my position that has been filled by every assistant attorney general at the DOJ since then, to work together with states, serve as a liaison, help coordinate state and federal antitrust initiatives. So that's how I became to work with the feds, and it really started with Anne. And then, of course, Janet Steiger and then Chairman Pitofsky succeeded her in working with the states.
And just to be clear, when you're talking about Chairman Pitofsky and Chairman Steiger, you're talking about the chair people of the FTC.
At the FTC,
okay,
yes.
Good. Just to make sure the listeners knew that. So let's talk about the antitrust authority of the state AGs generally. How does it compare, and how does it dovetail with federal antitrust agencies?
I think most people are surprised at the amount of authority that individual states have. So state antitrust authority or state antitrust statutes predated the Sherman Act. But for the most part, the states did not aggressively enforce their state antitrust statutes until maybe about the 70s. The Hart-Scott-Rodino Act, as we know, is kind of the main merger statute that requires a waiting period for mergers. But also in the Hart-Scott-Rodino Act, state antitrust enforcement was memorialized in federal law, and that state attorneys general were given express authority to file actions or to have standing to file actions under the Sherman Act, not criminal provisions or criminal authority, but civil authority, and gave states or confirmed that states had parens patriae, so basically being able to file civil actions and collect damages on behalf of natural persons who were injured by antitrust violations.
And
so,
when did this occur? Just so we make sure the listeners are grounded in chronology.
Well, the HSR Act was passed, I think, in 1975. I think it may have been effective in 1976. I should know this, but so in the mid 1970s, and that prompted states to update and modernize their state statutes. So every state except one has a general state antitrust statute that are patterned pretty much after federal law. So this is a trivia question. Which state does not have a general purpose state antitrust statute?
I'm going to guess Pennsylvania.
That would be your home state, Melissa. So that was not fair for you to answer that question. Because you're being,
I didn't know that. That is a very good trivia question. Why?
Yes.
Why doesn't Pennsylvania have its own antitrust statute?
It's not a state; it's a commonwealth.
Well, like Massachusetts, that's right. But we have one.
Like Kentucky, yeah. So it's not so much whether it calls itself a state or a commonwealth. I would say that probably a historical accident of sorts. Now, there have been 40-something attempts. We just cited this in litigation that we had, so that's why it's kind of somewhat fresh on my mind. 40-something attempts to pass such a statute. I think every attorney general since the 70s or certainly the 80s have introduced legislation. But the Pennsylvania legislature has never seen fit to pass a state antitrust statute. But again, recall that states have standing to bring actions under federal law, and that's what the state of Commonwealth of Pennsylvania has done. There has been recognized common law, antitrust law or competition law in Pennsylvania. Hotly disputed. Of course, we have a case right now where we're disputing that there is such a thing, and if there is, it's very limited. But yeah, so don't know why, but it didn't happen in the 70s, and it's very difficult now. It has been difficult, or has not been successful, to have antitrust legislation passed in Pennsylvania.
Sure. So let's talk about state antitrust enforcers working together. I know they've organized themselves into the NAG, the National Association of Attorney General's Antitrust Task Force. Can you describe that for our listeners and explain what that's about, how it's organized? Sure.
Well, the National Association of Attorneys General is the association. You can do maybe a trade association for attorneys general, and so NAG coordinates activity among attorneys general. They provide training across any number of fields, so not just antitrust, but charities, consumer protection, you name it. Supreme Court, they have a Supreme Court training advocacy program as well. So under NAG, there is an antitrust committee that are headed by attorneys general. And then the attorneys general then appoint the head. So the task force is a collection of state level antitrust lawyers, the chiefs of the various divisions and lawyers that work in those divisions are part of the task force. Every state that does antitrust and consumer protection, but we're talking about the antitrust task force, is a member of the task force. Some states are more active than others. And so this task force coordinates antitrust activity among the states. That could be, and we're going to talk about multi-state investigations. They coordinate amicus briefs, coordinate litigation, and their committees under the task force. So it was the task force that in their meetings a couple of times a year. So that's how I became involved and got to know lawyers from other states.
Actually, you anticipated my next question. I was going to ask you about multi-states. That's a term of art in state attorneys general world. Can you explain what a multi-state is, what prompts the formation of it, and how it's organized? Why is it a useful efficiency enhancing technique?
So a multi-state, as the name implies, it's any investigation or litigation that involves two or more states. And when I was first starting off doing antitrust in the late 80s, we found it, or the states found it, to be a mechanism whereby states can collaborate and pool resources. We saw ourselves as and I think this is still the case, as you can say, third behind the FTC and the DOJ enforcement agency when two or more states have an interest in a particular investigation, able to pool resources, share expenses, resources being, attorney resources and time and efforts. And so before the internet, AT&T, the then AT&T, not current AT&T, had a product whereby you could actually connect computers and send emails and send documents. At that time, it was WordPerfect, dating myself, where you could actually edit and share documents, things that we all take for granted now, but was somewhat cutting edge at the time. So a multi-state allows states to pool resources and to take on matters that may be too large, too complex, too expensive for individual states.
So let's pick up on that multi-state idea. Currently, there are a number of different multi-state actions going on. Can you talk about some of them? And I also talk about the fact that in some of these multi-states, everybody's involved, and some only a few are involved. How does that happen? And how do you, as a practitioner, help guide your clients through that maze?
Well, there are several well-known, publicized multi-state investigations and litigations, and we're involved in some of those, representing clients. So I can speak at just at a very high level. So, for example, a group of states have sued the generic pharmaceutical industry for alleged price fixing. That case has been MDL'd in Philadelphia. You have the so-called big tech cases, several Google cases, Facebook, you name it. And membership in multi-states, because these are all voluntary, and so So AGs become involved in multi-states because they see an issue that they believe needs to be addressed. They can often, at the AG level, solicit other attorneys general to be involved. That certainly for current multi-states has been the case. At the staff level, because we talked about the NAG Antitrust Task Force, that's also a mechanism to organize states who may want to be involved. They're usually 2 or 3 leaders of a multi-state. I think it's been very public in the drug pricing, generic pricing, that Connecticut is the lead state there. In the Google, I will say Google cases, because there are several cases. You have Texas has been active, been the leader in, say, the ad tech cases. Colorado and Nebraska are the leaders in search cases, working with the DOJ. So it varies. I think one thing to keep in mind is that even though we live in a very partisan environment, antitrust is very bipartisan. So you have the Colorado, Nebraska attorneys general are viewed as, and I think accurately, as the leaders in these so-called big tech cases with New York and with Texas. So we're talking about 2 Republican attorneys general, Nebraska and Texas, and 2 Democratic attorneys general, Colorado and New York, that are no doubt the leaders in this space.
So, and I take it from your description that when there are parallel proceedings, it's not because there are contradictory theories in those proceedings, but it's because, for example, Texas wants to focus on one thing and Nebraska and Colorado would rather focus on search. Is that accurate?
Yeah, it is accurate. Certainly, for the cases that are currently pending and investigations, some public and some non-public, it tend to be complementary. That it's just a matter of allocating resources. So the attorneys general and at the staff level, the antitrust chiefs, they collaborate and they decide that, well, you can focus your resources on this aspect, and we will take the lead on these other aspects of the case. So it's not they're not at odds. They're very, very collaborative, and they collaborate very closely with the DOJ. And this happened with the Trump Justice Department. It's happening with the Biden Justice Department, and it happened with Obama and presidents before him, and with the current Federal Trade Commission.
And how do you advise a client that's being investigated both in Texas and in DC and maybe somewhere else? It's got to create problems for them in terms of bandwidth and just logistical problems, I would think.
Well, I think that in terms of how do you address multi-states, I think some of the same practices should apply to dealing with any enforcement agency. And that is that you engage, with the staffs, understand who's taking the lead, on a particular issue, and engage on those issues. But it's important to kind of understand who really is taking the lead. And I said engaging with them. One mistake that a lot of people make is that they try to jump over the staff very quickly and start engaging with the attorneys general personally. And while they're, at the end of the day, the attorney general or the AGs collectively are the decision maker, but it's still important to engage with the staff on the facts and the law. as opposed to, well, I know this attorney general and I'm going to go talk to. It's fine to talk to the AGs, and we talk to the AGs a lot, personally, directly, but it's very, very important to engage with the staffs, because at the end of the day, the attorneys general are taking advice from the staffs.
Yeah, that's very good advice.
So I know we're running out of time, but one last question, Milton. I want to focus your attention on a case that has been brought recently by the D.C. Attorney General Karl Racine on its own against Amazon. And recently, the Justice Department, I think just this morning, announced that it was joining with the D.C. Attorney General in asking for reconsideration from the D.C. court on that. Can you comment on that?
Well, I can't comment specifically on that case, but I can say that as a general matter, that while we have, during our discussion, talked about multi-state and the fact that states do work very well together, collaborate at the attorney general level. The attorneys general get along very well in a very bipartisan manner, and the staffs, which are not partisan at all, work well together and collaborate well together and have very good working personal relationships. That does not mean that individual states will not file lawsuits on their own. And I think that it's a mistake to read anything into that other than an attorney general exercising his or her own prerogative to file a state either in federal court or in his or her state court, in this case, the D.C. Superior Court. So wouldn't read anything into that other than an attorney general exercising, in this case, his prosecutorial discretion to file a lawsuit.
Well, that's been great. Lots of good information, and we'll look forward to seeing whether state actions like the one in D.C. proliferate, or whether the trend continues to be perhaps more multi-state investigations and proceedings. But switching gears, what we'd like to do with you, Milton, as we do with every guest, is find out a little bit more about you personally. Can you tell us something interesting about yourself that's outside of your professional life?
Well, I think I mentioned at the outset that I went to Georgia, and it's state law in Georgia, unless, like my younger brother, you went to Georgia Tech, to be big University of Georgia football fans. So big college football fan. And we went through 40 years of no national championships, and Georgia being next door to Alabama, it has not been it's not been an easy time. I went to the last national championship game, not this one. I did not go because of the pandemic, but went 4 years ago. So I witnessed our losing to Alabama in overtime at the Georgia Dome. It was not the Georgia Dome, the Mercedes-Benz Dome, whatever the stadium's called in Atlanta. So that's my probably unbalanced recreational activity, cheering for Georgia.
Hope springs eternal for Georgia. And then the other thing we like to ask, particularly, the experienced folks like yourself, what advice do you have for a young lawyer who's looking to do what you do? Well, and we did not practice this question, but I am a big fan of the ABA antitrust law section. I was the Civil Practice and Procedure Committee chair, and I've been vice chairs of committees in the ABA. I was on the nominating committee of the antitrust law section. So what I have advised younger lawyers who are interested in antitrust, get involved in a committee, write articles, because the discipline of having to write an article, and there's so many opportunities to write short articles, the discipline of writing an article helps you substantively to understand antitrust law.
And so that's my advice. So I'm a big fan of the ABA antitrust section. I think that we have the best section in the ABA, if I say so myself. And I just think it's a wonderful resource for younger lawyers.
And I just want you to know that I did not pay Milton to say that.
That's right. Okay.
We did not rehearse that.
Indeed, that's probably one of the top 3 answers that we've gotten to that question from practitioners like yourself. And now for the final segment of this episode, we're going to play a little game that we call the Curious Hat.
And now it's time for the Curious Hat!
The rules of the game could not be simpler, Milton. All you need to do is pick a number between 1 and 10. I will draw that number out of the virtual hat and read you the question associated with it.
I'll do number 7.
Question 7. Tell us about a teacher who had a major influence on you.
A teacher. Well, I'm going to say my high school English teacher, Mrs. Leviston. I think I'm remembering correctly. It's been so long since I was in high school. And she was very firm, didn't mess around, and just really stressed the basics of grammar and writing, which is kind of the building blocks of what we do as lawyers. So I would, one of my favorite teachers.
Oh, that's great. Thank you, Mrs. Leviston.
Yes.
All right. Well, thank you for your time today, Milton. This has been a wonderful episode, and hope listeners will tune in next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.